Sir, it's 6 p.m. now, so I think we can start. You can unmute, and I'll just do the intro.
Okay, I'm not able to open my video.
You should be able to now, sir.
Yeah.
All right, sir. So, greetings to everyone present, and welcome to Biomax Weekend Webinar Series. I'm Ramya, a lawyer and mediator, and your moderator for this evening. BIMAC is an international not-for-profit ADR center that provides affordable mediation, arbitration, conciliation, as well as other ADR options. The topic for this evening's webinar is Alternative Dispute Resolution, the best option for micro, small, and medium enterprises. Our speaker for this evening is Dr. K.V. Omprakash, a corporate lawyer, arbitrator, and company secretary. Dr. Omprakash is the founder and director of Consentia Law Associates and Consentia Consultancy Private Limited. He has been in the legal profession as both a legal practitioner as well as in the corporate service since 1989. He is also an arbitrator on the panel of BIMAC. He's a panel advocate of SPI. He specializes in providing business and corporate legal advisory, FDI, M&A, FEMA, IBC, legal due diligence, corporate structuring, and represents various clients in courts, including the NCLT. He's an associate member of ICSI and has done his master's diploma in business management in finance from SIMS Pune Symbiosis. He was awarded Doctor of Excellence, PhD, by CIAC for his outstanding achievements in corporate law. Dr. Omprakash is the chairman of the Management Committee, Banking and Finance of BCIC, Bangalore Chamber of Commerce, and is also on the Corporate Affairs and Expert Committee. He's involved in mentoring and motivating entrepreneurs and startups, SMEs, and has been a speaker in professional training sessions for SMEs, companies, colleges, and institutions. He's a member in FKCCI and also of the Madras High Court Advocates Association. Dr. Omprakash is also a part of Rotary Means Business Fellowship Bangalore and is currently the chairman, for 2021. He's also been a district trainer of RI 3190 and chairman club services and was a past president of Rotary. It's an honor to have you this evening, sir. I hand over the floor to you. Thank you so much.
Good evening, everybody, and thank you very much, Ramya, for that wonderful introduction. And I thank BIMAC for having me as a speaker today. Thank you very much, Advocate Thiruvengadam. It's a wonderful opportunity for me to share what I have gained experience, and the topic given to me is MSME, all about MSME and the ADR. Why ADR is one of the best options for MSME is the topic today. I will just share the is it visible? Yeah.
It's visible, sir.
So today the order of the day is alternate dispute resolution. It's because of the time, the economy, and the importance of solving the issues amicably. So this is the main reason why the ADR has gained more popularity and is a welcome idea for all the companies. Now coming back to MSMEs, so they are the people who really create large exports, and they are the entrepreneurs who struggle if their payments are not received well in time. So this is the real problem of an MSME, and that's why we are here to discuss about how MSME can take the mileage on ADR than the traditional way of approach. So why alternate dispute resolution is the best option? So if you see the classification as on June 2020, MSME Act underwent a change and the definition itself underwent a change. So what is a micro, what is a small, what is a medium enterprise has been classified based on their investment and turnover. And if you can see here, micro is where the investment is 1 crore and turnover is 5 crore. Small, rupees 10 crore and 50 crore. And medium, it is 50 crore and 250 crore. So this is the definition or the threshold which was being redefined for MSMEs. Significance of MSMEs. As I was mentioning, small, micro, and medium enterprises have been accepted as significant catalyst in economic growth for promoting equitable developments. And it contributes 30% of the country's GDP and about 40% of overall export. So these numbers are mind-boggling. In terms of generating employment, they have created 110 million people across the country. So it's a wow. In order to encourage the growth of MSMEs, the government has from time to time implemented a number of schemes that MSMEs benefit greatly from. So the Atmanirbhar Bharat or the MSME Samadhaan, these are all the schemes which have recently come up to strengthen the MSMEs operational issues. The need for a dispute resolution mechanism. It was well necessary that the MSMEs have a particular way of getting the delayed payments. Many MSMEs fail to function efficiently due to delayed payments from the parties. Normally, at the time of executing the agreements, normally the foreign buyers or the clients, they bulldoze the MSMEs by cornering them, having a very tight agreement, having various classes which are one-sided, and MSMEs tend to sign agreements to get the business. In particular, these contracts fail to address the jurisdiction or the law, applicable law, and post-major conditions. These are the classes which they compromises, and indemnity classes also. So at the time of agreement stage itself, MSMEs get into a trouble by signing a one-sided agreement, and thereafter all these things start falling in place. So delayed payments. So when the defaulting buyers do not pay on time, the act comes into the picture. So the act has brought some mandatory requirements and norms which states that 45 days is the time within which a payment has to come in. Beyond that, a steep rate of interest at 24% is prescribed. So it's all in the law. Not that it has come today, it's all there. Only thing is how practically it is put and how MSMEs are benefiting with this act is all the challenges about. So normal commercial litigation is long time consuming, money is involved, travel, many companies' resources have to work on this unproductive work. So to resolve all these things, the MSME Act has brought in some changes. So if you see the dispute resolution under MSME Act, Chapter 5 of the MSME Act contains provisions under Section 15 to 24, which regulates delayed and default payment to micro and small enterprises from the buyer in case of any services availed or goods brought by him. For ensuring that payments are effectively made by the buyers and the grievances of the supplier are addressed, the state governments have established Micro and Small Enterprise Facilitation Center, that's council rather, it's called MSEFC, for settlement of disputes on getting references, filing on delayed payments. So this MSFE is obligated to decide a case within a period of 90 days from the date of making such a reference as per Section 18 of the Act. For filing a complaint with MSEFC, the supplier is not bound to issue a legal notice and he can straight away approach the Facilitation Council. Normally, when there is an agreement in place and there is an arbitration clause, normally the buyer tends to invoke the arbitration, and the section is very silent about whether the arbitration clause can be invoked or you can still go ahead with the MSME Act. So it is, we can put the advantages given, the benefit is given to the one who triggers first. So there is a small loophole here and it can be debated also. It can be contested. There are no fixed laws. So this is one challenge we have. So we need to have a draft in place, the agreement in place properly. So when you come to alternate dispute resolution, this is mainly available for not only MSME, for everybody. But since we have our focus is on MSME, these are the methods by which a resolution can be arrived at on a dispute in a non-litigation manner or non-traditional litigation manner. So arbitration is one. So we know about how the arbitration goes about. So it has a similar setup like a court and you have an arbitrator appointed. It can be a sole arbitrator or an arbitrator appointed by both and they in turn appointing a neutral arbiter. So the procedures are followed as per the Arbitration and Reconciliation Act. Then you have the conciliation, then mediation. There's something called Lok Adalat. There also you can settle your disputes. So these are all the sources available, which is less time consuming. So now, when we talk about MSME Facilitation Council, under Section 18, failure of the buyer to pay the sum will have a compound interest, is what it says. The council shall either perform the conciliation itself or seek the assistance of another conciliation organization. If conciliation is unsuccessful, the council may either take up the dispute itself for arbitration or refer the parties to an arbitral institution. And Section 18(4) provides that council or center providing the alternate dispute resolution services shall have jurisdiction to act as an arbitrator or conciliator in a dispute between the supplier located within the jurisdiction and a buyer, anyone who buys goods or receives services from a supplier located anywhere in India. So this is how the council works, and by and large this facilitation council is pro MSME, and since somebody has raised the hands, I will address the queries later on. Is it fine?
Yes, so the questions can be taken later on.
Yeah. So now when you come to MSME Samadhaan scheme, this is the portal, and the government has introduced an online delayed payment monitoring program called the MSME Samadhaan in 2017 to promote the submission of an MSME application. So the council was not very effective and many people were not aware about it. So this Samadhaan scheme has come in place. You can visit the website and see. If you click in MSME Samadhaan, you will get a portal. Any MSME which has a valid Udyog Aadhaar memorandum, that is UAM, can apply via this portal. So there are some precondition and list of checklists to be followed to apply an online application. So there will be some parameters and you need to upload it, and the size of the file should be within 1 MB. So there are a lot of do's and don'ts in that. So if you follow the strict pattern, then you can really upload the complaint and the complaint gets lodged. Once the request is made, the council shall examine the case and issue instructions to the purchaser unit for payment of the due sum along with the interest. So this is the simple mechanism which has been followed, and many of them have applied for this. If you see the process, normally once you apply in Samadhaan, after 15 days of submission of the application, the MSME issues notice to the buyer, then publishes notice to the local newspaper where the buyer receipts, after issuing 3 consecutive personal notices to the buyer in case the buyer does not respond. If the buyer does not respond to the notice issued by the council automatically admits that the claims made be the supplier are true and accepted by the buyer. Council reserves the right to pass an ex parte order also. If the buyer responds, the council then refers the parties for reconciliation so that the parties can settle their disputes amicably. The 90 days period starts from date of such references. If an amicable settlement is reached by the parties through conciliation, the council then passes a final order disposing of the matter. If an amicable settlement is not reached by the parties through conciliation, arbitration, or another means of alternative dispute resolution is sought for conducting its proceeding by the council. So the council looks at other options. The council looks into the merits of the case and evidences as produced by the parties and passes a final order and a binding order. It can be challenged by the buyer provided that 75% of the amount disputed is submitted to the court initially. So this is the process adopted by the MSEFC. Now coming about the efficiency, that is where the problem lies. It is very popular, but still there are a lot of issues and people find it difficult because it's a faceless portal, and if you see the cases involved in mutual settlements were only 3,263, having 376 crores involved, while the number of cases rejected stood at 6,446, having rupees 1147. These are all statistics. So is the MSME Facilitation Council efficient? So if you see the numbers, the disputes, a very minor part in terms of disputes have been addressed, and volume of the currency also, if you see, it's very bigger. Lot of other cases would have been either rejected or the buyers may not be available, absconding. So there could be 101 reasons for that. There are matters which got resolved, but however, if you see the ratio, the unsettled and pending are more. Again, if you see the number of payment disputes by mutual settlement, again here also same, disposed of is lesser than what is pending, and again mutual settlement also same. Why MSME should opt for ADR, arbitration over litigation? Now that's the point we are discussing in this session. What is the best mechanism? Whether ADR is the best route or a simple route of litigation, either going before DRT or NCLT under the IBC code, or filing a recovery suit, or a civil suit, or coming back to alternate dispute resolution. So if you see the money involved and time involved, the litigation may be suitable for large corporations, as they will be having a legal team. They will have they can engage top-notch advocates. But MSMEs do not have that luxury. They are only interested in their payments and they don't want to dispute or wind up other companies. As long as their payment is received, they are okay to move on in life. So that should be the spirit. But that's what is happening when the other large companies are taking advantage over it. So when it comes to the table of negotiation, they somehow crush it to pay 30-40%. Even that is okay for MSME because working capital issues are always there. So MSMEs should look at ADR but should not compromise on the outcome. It should follow the ADR route because it can avoid time, money, and resources also. So that's why we, even as an advocate, we suggest them to amicably solve the problems, since arbitration is a lesser time consuming and it's a summary trial, and the luxury and comfort of deciding their dates amicably, and it's held in a very confidential manner. So MSMEs can look at this route, and arbitration is not only for the large companies, it can even be for the MSMEs, and they should start bringing those clauses in their agreements right from the order procurement itself. These are all few are advantages available if we go on an arbitration route or an ADR route. Could be anything. Basically, the flexibility and control, the speed is there, low cost, of course, simplified rules of evidence and discovery. Unlike our court systems where you have evidence to be filed, marked, issues raised, then again examination, cross-examination. So all these things goes for years. Very easily crosses. You will have number of holidays coming in between. Somebody will fall sick. So a lot of things. So all these things can be avoided. The trial procedure can be avoided. More importantly, privacy and confidentiality is there in an arbitration proceeding, and you have the comfort of choosing your arbitrator and also the venue, place, and dates also at a mutually convenient date. You can have arbitration, and it will not disturb the operation or conduct of business. As I was mentioning, many people, many entrepreneurs, especially the MSMEs, do not go to a lawyer at the time of signing a legal agreement. So they do not know. So whenever they get an agreement, they only look at the commercials and the obligations, and mostly they compromise on matters relating to jurisdiction, arbitration, place of venue. Yesterday also there was a contract signed between a Bangalore-based MSME and a client in Ireland. So as a council, we said, please have an arbitration class and let the venue be a common place where either of them can travel at a common place and close the issues. So the client in Ireland is not accepting. They want the laws of Ireland to be followed. Jurisdiction also in Ireland. But the Bangalore supplier or the software service provider wants the client. So they had to ultimately compromise despite our recommendation of arbitration class. They said, as we grow, we will introduce her. So this is the state of situation today. The entrepreneurs have to at least take an yardstick measure, and you cannot have a dispute solved in some other land where we cannot go on even travel also. So this is something which is ridiculous, and many a times the MSMEs compromise on this. The attitude of take it or leave it also puts them in a very bad shape as to they finally agree to that terms. So this is the situation, and if you see many MSMEs should come out with or put down their steps and say, we need an arbitration class or a center which has multiple locations and which can redress their disputes on a video call. Today, Corona has given the new normal, and today a lot of disputes are getting solved. I understand from BIMAC as well that a lot of issues have been sorted out sitting at their places, their business places or at home, and disputes have been resolved. There are demonstrations available. So I think the entrepreneurs, or especially MSMEs, have to put their foot down and introduce such classes. Yeah, we will, okay, if it is your law also fine, we will only accept with an mediation center or a arbitration center which has multiple geographical location. So let us have that draft or clause in our agreement, and the lawyers should be able to impress on that. So that is the way forward. Otherwise, you will end up in the entire money would go in a litigation, and you may be even making a loss, time consumed, and the award cannot be implemented. All these things should not complicate. So that's the importance of an arbitration clause in an agreement. How does it differ from traditional? I don't have to explain, many of them know this. The cost is lower, the time consumption is lower, and there are amicable way of settling the cases out of the court, and there are immense chances for the heads of the organization to have a face-to-face meeting, which normally only the operational level people would have got into tussle, bringing to a deadlock. I'm sure if the owners or the business promoters start talking to each other, there will definitely be a way out. Here, nobody is there to fight and quarrel. Ultimately, business. I have provided some service. There can be some shortcomings, or I have provided something which you did not want, or my product is not matching your requirement. All these things can be sorted out. If there is a technical thing to be discussed, this is the best way to solve the problems. And no wonder in the traditional court, you may not have that luxury that technical people are involved. So in an arbitration, we can always get the technical report. Even in the traditional also, we can do, but it will take a lot of time because a commissioner has to be appointed and it will drag. So if you see overall, when you assess the arbitration or the alternate dispute resolution to the traditional litigation, definitely when you take the time concept or money, definitely less, and a holistic solution can be arrived at. So with this, I would like to emphasize that MSMEs definitely would surely look into the option of ADR than to prefer the traditional litigation route, because time is precious and the new normal has also taught us how to come to a conclusion from their respective places, and the court has also understood a lot of litigations are happening on video conferences. Everybody knows, those our lawyer friends who are here will understand this. Supreme Court, High Court, NCLT, all are happening on video conference. Likewise, ADR is also no exception. So with this conclusive note, I would like to end the talk and allow the forum to interact or have any clarifications to be done. I'm here. On to you, Ramya.
Thank you, sir. Thank you so much for this insightful session, Dr. Omprakash, and for taking us through the various statutory provisions as well as the legal loophole, and giving us an overview of all the ADR options available as well. And also specifically talking about the MSME Facilitation Council, as well as how efficient it's been and how there's a lot of scope for it to improve. And while there is scope for it to improve, and there are several cases, it just clearly goes to show that MSMEs should utilize ADR options. I'd like to open the floor for questions. So if any of the attendees have any questions, you can feel free to put it in the question and answer box or in the chat box. So one question that comes to mind is that how do you advise as a counsel when you have an MSME client and they are probably involved with, let's say, a client that's like a big corporation. So you have a big corporation on one side, and you have an MSME, and they're being strong-armed into, let's say, going in for arbitration in London or Singapore, but that's clearly not affordable for the MSME. But they don't want to lose out on that business opportunity, but they still want to go ahead. Like, as a lawyer, and how would you advise your client?
See, as I was mentioning yesterday, there was a typical case where I was suggesting, okay, you are contracting with a client in Ireland. Why don't you have your arbitration class in place? And they were not in a mood to even compromise on that. Normally, the foreign companies, a large company, they have a template, and the legal department would have freeze the document. And if there is going to be any deviation in any of the clauses of those agreements, it has to go up to their legal counsels, and they have to approve, and it will go to the management, and then it's a process to be followed. That is what they say the Indian counterpart or any other person who's trying to have an agreement. So when we go with these classes and say they say, first of all, they don't even encourage. They first of all they don't encourage, and that is where the uh, question comes: how a lawyer has to be very productive and bring value here. The client has to somehow impress that my agreement with you is only an engagement where I am going to contribute so much, and if I am going to have such classes, and if something goes wrong, and I have to only spend time and money on unnecessary litigation, and the money which I have earned will be much less than my expense itself. So this is something they have to try to make them understand. See, again, people do not envisage or expect a problem. So if in case it comes, we will look at it thereafter. So there are operational level people, the marketing people would like to close the agreements, and because they are all driven by the sales incentives. So one agreement is gone, their incentive is gone. So this is how it works. And the advocate should somehow, the person who is vetting the document should somehow get in touch with their counsel and try to bring a small conditional. Okay, fine. If it is your law also as well, right? Let us have something. We will first refer to a arbitration center, and if we fail, we will get to the next level. So one reconciliation dispute resolution class should be there to the next level. So it depends upon the advocate to really impress on that, and he should be able to crack it and talk to their counsel and make them understand what we are trying to say. It is not that we are refusing their contract. No, it is not so. We are only trying to say, make it ease of doing business is what we are trying to say. When you are talking about ease of doing business, ease of solving your problem also should be there. So this is what we need to bring. And maybe if some bodies can impress people, like I'm also part of BCICA, we are also trying to bring this in our members, that you please adopt a standard class, and even in the MOU stage itself, you should start mentioning this, so that when they are bringing the final draft, they understand, okay, this guy is not going to accept it. Otherwise, you will be taken for granted. This is something, and I saw one in the chat box. How do you think ADR awareness can be created among MSME? Yeah, this awareness program has been happening. Many MSME workshops, seminars have been conducted, but everybody is interested only in finance. MSME is only interested in vitamin M. What will I get? What scheme is there? How do I grow my business? Who will invest in me? How do I expand my facility? So these are the only thing their attention is, because MSMEs do not have a legal department as such. Only when a summon or a notice comes, they go to a lawyer, and there also they do not know how to distinguish between lawyers who are best suited for them. So there also they look at who can help me out. I need to only reply this legal notice, and I need to only appear before the court. So they don't know how to proceed. So they should, even though they do not need to have a legal person in the company, at least they can have a lawyer on their board as an advisory, a legal counsel. Maybe they can take their help, at least to see where they go wrong. Every agreement should be vetted by him, so that he can at least tell them there are risks in this agreement, so that they understand, okay, this agreement has certain clauses. Normally, MSMEs fail in maintaining documents. When they supply, when they deliver software, the signing off is not happening because they are not having quality certification also. So documentation is very important if your legal jurisdiction clauses are tight. So they have to be very careful in that areas. So coming to the awareness program, yeah, definitely a lot of awareness programs are being conducted, and uh, 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 arbitration centers like BIMAC and all has to definitely try to uh, coordinate with various platforms like MSME training centers. So where you can make a exclusive session for ADRs and the importance of it, and give success stories, and also those cases where the litigation has ruined various MSMEs. So this could only bring awareness.
Thank you, sir. We have another question with respect to your views on whether company secretaries and chartered accountants, cost accountants should get involved in ADR and undergo mediation or arbitration training, because there's an increased need for domain expertise as well. So, since you are also highly respected among the company secretary circles, sir, what are your thoughts on this?
Yeah, today the chartered accountants and company secretaries are prone to a multifaceted exposure. They are no more only the bookkeepers or checking the audit. Their responsibilities have grown bigger, and the forums like NCLT tribunals are recognizing the chartered accountants and the CS to represent directly. Yes, there were initial issues where chartered accountants, cost accountants, or the company secretaries were not able to represent properly like any other lawyers would do because of the traditional behavior pattern or whatever it is. So now they have also been disciplined. They have also have a code of conduct and how they have to present themselves. There are some strict rules which have been laid by each institute. On the mediation, definitely yes, chartered accountants and CS have a good role because they understand the financials of the company. Sometimes with the lawyers may not, because their area of proficiency is different. So when it is a dispute of commercial nature, I think they can even excel. It's only more of understanding the commercial elements and giving a solution, understanding the balance sheets. Normally, litigation, a hardcore litigation lawyer will definitely look at an accountant to help him when it comes to depreciation, when it comes to transfer pricing. A person with multiple streams only will be able to apprehend the dispute on hand. So I would definitely say the chartered accountants and the company secretaries should take this up because their scope is also increasing. They are doing a lot of other things also. They are also being recognized as independent resolution professionals and under the IBC. So there also they are doing a multifaceted activities. Not alone, they also have an entrepreneurial role to do there while distributing the assets to the creditors. So this ADR will help them definitely in resolving when they come up with a resolution plan in NCLT, and they can sort out various things even during the process of resolution process by adopting this ADR technologies. So I think they should be successful in arbitration also, at least even in mediation also.
So we have two connected questions. One is from one of our board of governors of BIMAC, actually, Mr. Ghanshyam Das, who is formerly a consultant at KPMG and at NASDAQ. He asks, the MD of NASDAQ, he asks, would it help if regulators can encourage that for any dispute resolution, MSMEs must first try ADR before proceeding through courts? The connected question is whether, it's from an anonymous attendee, it's whether ADR should be made compulsory for MSMEs through an amendment in the Act.
Compulsion may not be possible, but certain guidelines can be given to the MSME. See, if all the MSMEs start retarding in their agreements, and they give a sense of feeler to others that the arbitration or the ADR should be a mandatory provision in the agreement, yes, definitely it will happen. Definitely the government has a role to play in that. Definitely it has a role to play in this, and but making it compulsion may not be possible at this point of time. But yes, definitely awareness should be brought in, and that's how the government can help. That is why they have created a facilitation center also, and you have Samadhaan in place. But many of them are stuck with them. What government needs to be doing is creating a platform, and having a center will not help, but it has to show result. The belief has coming down. So on one of the other forum where I was talking, there were open questions shooted across, and it was an MSME forum. They were trying to say Samadhaan is not effective, and I have a case, and it is not fetching me any result, and I have lost time in this. Now I cannot again start my dispute resolution. So there is a kind of setback in the procedures, and people are clueless what happens to their complaint. So these things should be removed. So the only way is, you have a arbitration center marked in your agreement. This is the place, and this is what we are going to do. And we know when there is a dispute, who is going to be our arbitrator, where are we going to redress, whether that center has a place in that particular region, if it's from abroad. So the comfort is there. So that should be the approach. And I think the ADR also should bring more innovative concepts to reach MSMEs. And without MSMEs trying to take this, we will be only talking in the air. So today what is happening is MSMEs do not have time to talk about the dispute at all. They are bleeding. Their only requirement is money, working capital, how they grow. So when we are talking about these three categories, and when we make a workshop or call for seminars on alternate dispute, there's a very, out of 100, you will find only 10 to 15 people who are attending it. But if you have a workshop on what are the ways to raise capital, you will see 60%, 80% attendance. So their focus is different. And it will take time. And we should give a time, and people should provide some legal services at a. So what has happened is today legal services are also becoming expensive. To engage a lawyer, it becomes expensive. The moment you talk about vetting an agreement, when we start quoting, they shy off, and they take a call and they move on. So these are the issues with MSMEs. So MSMEs is a really a tough nut. Their requirement are different, and they are not in a situation to adopt things which are beyond 2 years. Their level is only at 2 years, and they only do the fire putting now. Even GST or statutory dues. So those are the pressing issues. Even the one-time settlement, when the government gives enough opportunity, also they miss the bus. Later on, they sit and crack their head. So this is the situation of MSME, and we can't blame them also, because government policies are changing, ease of business is there, but still there are a lot of returns to be filed. For example, if you take GST, there are a lot of things to be compliant. Every fifth, seventh, a lot of things to be filed. So if you miss something, you will get a summons. Then you have a labor law around. So with all these things, MSMEs are really a kind of set of people who are in the race. So to bring them, it's our duty to really nourish them. And this mechanism, even the court also has a mediation center. Only when you file a case, you can refer to the mediation center. There's something called Nyaya Dagula. There you have a mediation center. They do a good job, fair deal job. You get a result within 2-3 months. Set of arbitrators are there, mediators are there. But the question is, mostly it goes back to the court because somebody doesn't cooperate. So the system, by and large, is not very conducive for the MSMEs today. So this is what I can say.
Right. So I think that's very true with respect to how they have so many other concerns that ADR or dispute resolution only becomes a hindsight because they don't expect a dispute, and they don't expect or anticipate the costs involved. Ms. Komal Bora has a few valid points and suggestions regarding Taluk courts awareness training sessions for ADR, as well as whether the need for online dispute resolution mechanisms, as well as to make ADR transparent. And she also wants to know your views for different rooms in court for providing information about ADR mechanisms alone.
The Taluka courts awareness training session. Definitely, there are sessions happening at Taluka levels also. But how far it is implemented is a question. But yes, it can be arranged. Trainings can be arranged. Definitely, we can go to the tier 2 cities and arrange for these kind of trainings. The judge themselves has to, at the first hearing itself, they should try to negotiate and bring the parties in a negotiation mode and try to redress it. So a judge has a good role to play if a part of a training is given to them, though the papers have come to him on the table. Instead of conducting the trial, they can call the parties and ask them what do you have to say, what do you have to say. Especially the consumer forum does this. Many consumer forums, the presiding officer definitely calls both the parties and insists that both of them should be present on a particular day, and the presiding officer asks, would you refund it or will you give a new product? So like that, he somehow makes it viable and the matters are settled. So even a Consumer Amendment Act also has brought mediation center also. So there is a likely to have a mediation setup there also, but nothing has taken shape. So what was the other question, Ramya?
So one question from so the other question from Ms. Komal was with respect to online dispute resolution and how we need to make ADR transparent. Now, I was also thinking of something you said during the presentation where you said that there's a portal online that they can use, but it's faceless. That's currently in place, the Facilitation Council's portal. So, if there's online dispute resolution as well, um, how would it have to differ from this portal, and what are the safeguards that we can take to make sure that it's firstly transparent, and also we have the trust and confidence of the MSMEs, so it doesn't turn into failure like the faceless portal?
Yeah, see, um, when it comes to dispute resolution, normally what happens in an arbitration, we tend to have a venue. We get the arbitrators there, the counsel goes there, the parties have to go there. So that can be avoided on an online or a video conferencing. However, the paperwork should be done physically, or even you can have it digitized also. There should be a face, and we should definitely know whom we are dealing with, and not like Samadhaan, where you file it and you take and see the status of it. Instead, this is the arbitration center, this is the paper I am going to give. There are people sitting there. In case I need to contact them to find, I should be able to talk to them over phone. It is not that a customer care number is there and I keep calling them and we get recorded speeches. So that should not be, that will definitely put anybody down. And whenever people want to visit the place, they should be able to. So only the proceedings should be online. Like, today High Court, I feel very comfortable. Today High Court, you file everything, you deposit everything in the registrar, then your case comes for hearing, and you are able to precisely in 5 minutes, 10 minutes, you present your case, your argument is over, the judge understands what you are saying. So this is possible. This is really possible, and I would say this is a good idea actually, and we should try this out. ADR should, I think, by now BIMAC must have been doing this to their clients. I'm sure Corona would have given them a very good mileage, and many disputes would have been sorted out during the 8 months. Many disputes would have come to a conclusion. We would have gone through the entire process, which would otherwise be a physical, having a place where you will have the parties inside sitting there and exchanging papers and then spending time. The whole day is gone. Even in arbitration also, when you talk about proceeding, it's a day affair, from morning to afternoon, and it may even prolong. But on an online, I think it makes more simpler that the arbitrator need not to travel, he need not to uh, 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 be dropped and picked up. All those things can be avoided. Papers can be sent across to him. Some people do not like to browse the paper, and when in the argument stage, you can't give the documents. And but yeah, these things will evolve. But definitely, the even after COVID subsides, I think the ADR should have this option, and I think this option will definitely be accepted because it is less time consuming, and the hearing happens uh, in the premises itself, so you don't have to travel. Once you make a hearing date is given, that day is gone for the entrepreneur. So you don't have to worry about that. Still, you can look at the business 1 hour arbitration online. Definitely, it makes sense. So I think that should be implemented, and it should be the way forward also. And even for advocates also, it becomes easy. They prepare, they have everything on the folders, and definitely it should be the way it should be done.
Yes, sir, rightly said. And BIMAC has been conducting several online mediations and arbitrations. And we also have our electronic arbitration system, which is an online portal. It's called EASE, and we're revamping it. So that should be relaunched again shortly. So we have a question with respect to your opinion on whether ADR is better for dispute resolution between MSMEs and banks instead of approaching forums such as the DRT, and whether you think settlement can be reached effectively. Because anyway, like most banks have OTS schemes, but it takes a while to reach that. But instead of knocking on the doors of the DRT, if they have, I guess, a pre-institutional mediation or try and restructure or work something out, wouldn't that be better, so especially for the MSME?
The MSME, when they go to DRT, again, DRT has a set of rules and they follow, though it is a summary suit, they also follow their process, and the files which are there in DRT is also too many. The dates, the next hearing is next 3 months. You go today and just file your wakalat and say, I will submit my objection. The next date is March. Last November, one of my junior went to the DRT and filed an wakalat, and we wanted a short date to file our objection, March 15. So in a year, if they are going to give 3 dates, so imagine what will happen to the case. So I think MSME should definitely look at having a separate way of solving their problems. Yes, today we have Samadhaan, but that's not enough is what I feel. And the next level is the arbitration centers and the Arbitration Reconciliation Act. So there is a gap. So today dispute resolution for them is only to get their payment. Beyond that, they don't think anything. They have only 2 issues. One is the financiers giving them a notice. Second thing is they don't get their payment, or they have statutory dues payment. So all these things, if MSME can have a summary ad hoc kind of like somebody has mentioned, like Lok Adalat, why is it applicable only to telecom companies? Why not for MSME? Yes, definitely it's a good idea. So innovatively it should come. So these kind of bodies should be created. So even in RBI disputes also, we have certain mechanism to be followed. Okay, and what is that called? I forgot its name. In RBI, there is a ombudsman. So something like that. We should have something for MSMEs also, specifically to have their issues. I think definitely the agencies and the departments will definitely find out ways. They are also trying to have their own mediation centers, and they will definitely empanel the mediators and arbitrators. And as lightly said, the training should be given to more professionals, including engineers also. They think engineers normally think we recently had a survey in BCICI as to how they welcome about the ADR and a facilitation center exclusive for it. The response was very good. But when it comes to training, maybe 3 out of 10 are interested, because everybody cannot be a arbitrator or a mediator, because they don't think it is their cup of tea, and there should be an inclination towards this this discipline rather, as to hearing both the sides and then involving. It's more of a case study, right? So not many are oriented towards that. Definitely, when a large number of people get trained in this area and they are able to crack and bring solutions to MSMEs and dispute resolution happens, I think the other professionals also will start looking at this as one of the core area. That's what is missing today. What happens is you have few lawyers who are specialized in ADR, and there are little mediators from different domains, engineers or any other domain. If you take, there are not much. So if this number increases, so and there is a little competition among themselves, then it becomes more easy for MSMEs also to get a good deal. Ultimately, how much they can afford is the question. We can talk all these academically, but when it comes to an set, what is my cost to fight a case? If I'm going to have allocate this much for my dispute resolution, why not I go and settle now itself instead of waiting and going ahead? So these are some areas which everybody has to look at. MSME is, it's really very important for the economy to grow, and their disputes should not be neglected also. And many MSMEs have got bad orders and they have ruined also. So we need to protect them by bringing a cheap model available for them to have the dispute resolutions done. So I have seen BIMAC's website and all. So the pricing and professional fees and all is quite optimum. So anybody can afford, but how far they are aware is the question now. So, and we cannot keep advertising also. So we have our own code of contact also. So the awareness program is the need of the hour, and large companies have to look at MSMEs, and they should also try to accept the ADR more. Then only it happens, because I have seen large companies having their arbitration classes. They have their arbitrator venues. So sometimes they go to Singapore. They select the Singapore as venue. A dispute between Bombay and Delhi registered office, they select Singapore office as their venue. So these are things which can be avoided.
That's true, sir. It's almost like they're trying to cover up a wound, but then they end up bleeding from other portions of their body. On that note, sir, there's a question from Mr. Sandeep Christopher, who asks, what is the feasibility of arbitration in cases where the claim amount is nominal, say 2 to 3 lakhs? And I think if people are more aware of institutional ADR centers and the fee structure, they wouldn't really have this sort of query, because ad hoc arbitration is known to be expensive because of ad hoc arbitration and arbitration in London and Singapore, like you said. So I guess, what are your thoughts on ad hoc arbitration in MSME, sir?
See, MSME, when you talk about any dispute, anything beyond 50,000 for them is a no-no. So look at a dispute resolution when we are talking about 2 to 3 lakhs. So they need to really, they will think twice. So, and MSME is also, I'm talking about those which are below the, 2 crores, 3 crores, 4 crores, those kind of turnovers. So there are MSMEs which are doing much bigger one. They can afford it. Yeah. They do really afford those kind of cost. And awareness is very important. And the accounting people in MSME play a multitasking role in MSMEs. So the awareness should be brought in that area. So they may not be having a typical CFO. They may be having an accounts head. So if you can tap them and educate those people, or MSME normally have a multifaceted person who will be doing multitasking. He will be sales and he will be looking after the commercials and also the accounting. When it comes to a dispute, he will be negotiating. So these are the people who should be educated, and awareness should happen there. And they should also budget. MSMEs do not budget for litigation or legal expenses at all. So in the budget process, they should have a budget in place. So in a year, maybe 2 to 3 lakhs is going to be my legal expense. So they are mentally prepared. Anything in this number, I give you approval. So this thought process should come.
That's true, sir. Mr. Thiruvengadam also states that MSMEs can use neutral evaluation facilities of ADR centers to help minimize their risk and cost of litigation. So that's basically where they get to assess their dispute to see which ADR option is best suited for them instead of simply rushing to court.
Yeah, see, this neutral evaluation facilities, they are aware. It is not that they are not aware. Again, normally MSMEs, what they do is when there is a dispute, first person they approach is their chartered accountant. Even today, we like it or not like it, without any prejudice, I'm saying, the chartered accountants are the custodians of their financial books and accounts, and even they take care of their legal matters, and they are the people who really engage the lawyers. So this is what mainly happens with MSME. And going to tier 2, tier 3 cities, it is still worse. Those people do not know how to differentiate between a chartered accountant and a company secretary. For them, lawyers means it is only criminal and civil dispute. So company matters, any dispute is chartered accountants. So when the chartered accountant start giving advice, so he should be the person who should imbibe this know-how. Okay, why don't you have arbitration center to solve your disputes? So I think we should address the chartered accountants fraternity. Maybe we should have a awareness program with them. So because they are the people who deal with most of the MSMEs, their annual accounts. So due all these contingent liabilities, they are only aware, and they are the people who redress the tribunals. They approach the tribunal and solve their problems. Likewise, litigation also, if the chartered accountant himself is a well-trained arbitrator, your problem becomes smaller because he himself knows what is the value about it. So I think the multi-institution people getting into this training makes a lot of sense, because the MSMEs ultimately should get the know-how that ADR is the best platform for them to solve their issues than going through the traditional court ways. I think that's how any arbitration center or this alternate dispute resolution should be looked at.
Right, sir. Mr. Thiruvangadam also adds that although MSMEs contribute to more than 33% of GDP in the past few years, the growth value has slumped by 12% because they are scared of recovery of credit sales, scared of disputes, like you said. So Biomax ADR actually provides for recovery of claims as low as rupees 20,000. But as you said, it's all about making them aware that they have these options and they won't bleed if they choose institutional not-for-profit ADR centers and choose ADR as well. So with that, I think we're out of questions, and I'd like to thank you so much for your valuable time, sir, because I think we're also running out of time. And this session has been incredibly enriching and useful, and I'm sure all the other panelists watching live on Zoom as well as on YouTube agree with me when I say that we've learned so much, not just about the act, but also with respect to why ADR is important from MSMEs and also from the perspective of MSMEs and how they view dispute resolution, as well as the key people involved with respect to MSMEs and taking calls on how to resolve their disputes. And this is huge in terms of how we as ADR institutions and ADR neutrals and professionals, as well as lawyers, should approach MSMEs and tactfully handle these disputes without ensuring that they stay in court for a very long time. So I'd like to thank you very much, sir.
Thank you, Ramya, and thanks, Mr. Thiruvangadam, for giving this opportunity. It was pleasure to address this gathering. Thank you very much.
Thank you. Stay safe, everyone, and goodbye. Thank you.